at the Colorado Supreme Court in Denver, Colorado. We're going to wait just 10 seconds or so to get people get signed up and logged on. If you're watching this, we want you to host a share party and post comments on where you're watching from, especially. And we're going to have a recap of what just went down in the Colorado Supreme Court. So it's not quite like a football game, a post-game show, but a little bit. So as you're watching, please share, comment, like, and host that watch party so others can hear what happened today. So in the courtroom behind me, our attorney, Rocky Mountain Gun Owners attorney Barry Arrington here, just argued in the first gun case in the last 15 years in front of the Colorado Supreme Court. And we just ended a 6-year, 2-month fight to get rid of and strike down the Colorado magazine ban.
Started in August of 2013, when the trial court dismissed our complaint. We went up to the Court of Appeals, got that dismissed, which means back to the trial court, had a week-long trial, back to the Court of Appeals, and now we're at the Supreme Court. That took 6 years. It's been a long, arduous fight.
Kind of a funny up and down and up and down. And just to be clear, this is the court case on House Bill 1224 from the 2013 legislative session in the building right across the street, where they limited the magazine capacity for firearms magazines. And there were other cases. There was one other case that went on in federal court. Our case was on the constitutionality based on the Colorado Constitution and Article 2, Section 13 of this magazine ban. There was a federal case that got dismissed, and that one was done a long time ago. Now, so if you're watching this and you say, hey, let's appeal it all the way up to the U.S. Supreme Court, that's what you're trying to do. No, actually, we're not trying to do that, because you can't do that with this case. And why don't you tell our viewers here why?
So Article 2, Section 13 is a provision of the State of Colorado Constitution. The Second Amendment is obviously the centuries-long legal standard that when it comes to interpreting or giving a final analysis of a state constitution, the state Supreme Court of that state is the final arbiter, has the final say, which is for those of us who are in favor of the 10th Amendment and federalism and states' sovereignty, that's actually a good thing.
It's a good thing. So this is the end of the road.
This is the end of the road.
So I don't know, maybe there's a little bit of relief in both of us, just because it's been an expensive, time-consuming, long, arduous fight. And other questions in a minute, but let's talk about what happened here. So it was oral arguments where you made the argument for Rocky Mountain Gun Owners and the National Association for Gun Rights on this case, because we're the petitioners, and then the state Attorney General's office made the argument for the state, or Jared Polis, now the governor.
Who is the defendant, that's correct.
Who is the defendant. It used to be Governor Hickenlooper.
That's right.
Now it's Governor Polis. And it was supposed to be a 30-minute argument, but there's a lot of give and take and questions. And can you tell us?
So it was a 30-minute argument per side, so an hour altogether. And so what first happens in a Supreme Court argument is that you have your briefs. And when you include the amicus briefs, there were several hundred pages of briefs, and the justices read those briefs actually before today, and so that the oral arguments are placed into context. And so when you get to the oral argument, you're not really making your case for the first time. You start out basically saying a lot of the same things you said in the briefs, but the purpose of it is to give the justices the opportunity to say, hey, wait a minute, I've got a question, why don't you address this issue? And so making your case is not really the purpose of oral argument. Responding to justice questions is, and they ask a lot of good questions.
Yeah, it was a lot of questions. I was kind of surprised. I didn't think it was such an austere room. You'd think, oh, well, they're not going to interrupt. Well, oh boy, they do. And
yes.
It was kind of interesting. Reminds me a little bit of the House of Commons in England.
Yes.
You don't quite yell at each other, but there's some of that. And of course, not only do we file briefs, the state files a brief, but then other people file
As a plural.
And they file briefs. And one of them here, we had one of the attorneys here, Richard Westfall was here. He had filed a brief for some of the sheriffs who were in the other case that was dismissed, but he ended up filing a brief for our case. Right?
So we had 30 sheriffs come into this court and say, Your Honor, you should overturn HB 1224 because the citizens of Colorado, this is not Barry Arrington, this is not Dudley Brown, this is not RMGO, this is 30 sheriffs of the state of Colorado saying citizens ought to have the right to have, and they say large capacity, standard capacity by and large magazines for their weapons when they're defending against criminals.
And that was a part of this debate was, you brought it up, was no, it's not a large capacity magazine, LCM, it's a standard capacity magazine. And you made the case that because when you buy an AR-15 in any state that doesn't have a limitation, what's it coming with?
It's coming with a 30-round mag.
So that's the standard.
You buy a Glock 17, it's coming with a 16 or 17-round mag. And so I think I've been guilty of this, of kind of buying into the other side's terminology. These are not large capacity magazines, they're standard capacity magazines. LCM is a political term, it's not a gun term.
Right. And it was really used as a way to vilify.
Sure.
If they could have made it stick and called them Darth Vader magazines, they would have.
Right.
So I know you cited, of course, the McDonald case, the Chicago case, and which is interesting since we were cited in that decision.
Your brief, sure.
In our brief, Rocky Mountain Gunner's brief in the McDonald case was cited by Chief Justice Alito in the majority opinion, and where they incorporated the right to keep and bear arms to the states. And I think what bearing did that have on this case and the Heller case?
So McDonald was a game changer, not only at the federal level but at the state level, because Robertson said that the effect of Robertson, according to not Barry Arrington or RMGO, a panel of the Court of Appeals in the case called Trinan, said the effect of Robertson was more or less to read Article 2, Section 13 right out of the Constitution. Now that McDonald's have made clear for the entire country, not just Colorado, not just Washington, D.C., but for the entire country, that the pre-existing right to keep and bear arms that goes back centuries is a fundamental right, the Robertson standard, we argued, is no longer tenable because it doesn't treat it as a fundamental right.
And that discussion happened here about whether it's a fundamental right. Of course, it happened in the trial court, and even the state couldn't really argue that it's not a fundamental right. I mean, they kind of dance around it. They want to avoid that discussion, don't they?
Well, again, in the question session, the justices pressed the state's lawyer on the fundamental right issue, and he said, well, you don't have to decide that. Well, you do have to decide that. If you're going to have a standard of review under the Colorado Constitution, you have to decide what level of right you're reviewing. It's just basic common sense. If you're reviewing street improvement ordinance, that gets one standard of review. If you're reviewing a pre-existing fundamental enumerated right, that gets a whole nother level of review, a much broader level of review.
And you cited a First Amendment case, which I love doing, applying it in the same manner to the Second Amendment, because most people are absolutists on the First Amendment. I know I am.
Sure.
And I don't think government has any ability to regulate my First Amendment right before I commit a crime, right? Okay, after you've done it, you can penalize people. If you yell fire in a crowded theater, well, yeah, of course you can. If somebody has violated a law at that point, but up until then, you can't prior restraint.
Right.
Prior restraint is the concept, and control is like taping people's mouths shut right as they walk into the theater because they might yell fire.
It is a very good analogy. A magazine ban is the Second Amendment equivalent to prior restraint, saying you can't speak on this subject, for example. And what we argued is that in Colorado, this court has held in the First Amendment context, in the Fourth Amendment context, in the Due Process Fifth Amendment context, that the Colorado Constitution provides greater protection than the First Amendment, the Fourth Amendment, and the Fifth Amendment. And so how do we know how much protection? The court has set up a test. It's called a text history tradition test. If the text of the Colorado Constitution says, well, yeah, that text is broader than the federal text. If the history and tradition of the people of Colorado say, well, we've protected this liberty to a much greater extent than in the nation as a whole. That is the test. for the First Amendment, the Fourth Amendment, and the Fifth Amendment. We're saying it should be the same test for the Second Amendment. And if you look at that test, the text, shall not be called in question, is broader than shall not be infringed. Defense of person, property, home, much broader areas of significance. And so the text is clearly broader. History and tradition, the state's own witness said there were no guns bans in the founding period. And as a matter of fact, HB 1224, passed 138 years after the 1876 convention, is the very first time the General Assembly has banned any firearm or firearm component. So it breaks a 138-year tradition. So if you use the same test that they've used for these other constitutional rights, the result is Article 2, Section 13 provides greater protection than the Second Amendment, which the court has already implicitly held, because in a couple of cases the court has held, Nakamura, aliens have the right under Article 2, Section 13 to possess firearms in Colorado. Not so under the Second Amendment. Under certain conditions, felons have the right to possess firearms in Colorado. People versus Ford. Not so under the Second Amendment.
What's that?
So we do have a question.
We got a question.
What was the court's decision today?
Well, yeah, we'll get to that in a minute. There was no court decision. Why? You also made the, there was a kind of a question brought up by one of the justices. How many rounds does it take to defend yourself? You know, more than 15 rounds has never really been used in the state of Colorado to defend yourself. I don't know that you can actually say that, but they, you know, your point was, why don't we should let citizens decide how many rounds they want and need for their self-defense. It's not, government has no interest in telling citizens how many law-abiding citizens how many rounds they need.
I said to the court today, the courts just don't know what the proper number of rounds. I don't know. Dudley doesn't know in any given context how many rounds are going to be necessary. So if you don't know, what do you do? Well, Heller, the Supreme Court says you defer to the choices of the citizens. If you have a firearm or a firearm component that has been overwhelmingly used by only law-abiding citizens for lawful purposes, it's protected by the Constitution. We don't have to engage in this, do you really need it, sort of analysis.
Right. And of course, need is another question. Wow. But then there was also a discussion about law enforcement, and House Bill 1224 has an exemption for law enforcement. So law enforcement doesn't covered under this magazine ban, and yet most law enforcement officers don't even fire their gun in their entire career. Well
over 98% of law enforcement have never fired a single round in defense against a criminal, and so if what has happened in the past is the measure, why do we let law enforcement people have extended these larger capacity magazines?
And then the corollary to that is, why not just say that law enforcement, let's figure out how many the average or the max number of law enforcement rounds ever been fired in the state, and law enforcement can't have that many.
Because they don't need them.
Because they don't really need them.
And again, we had 30 sheriffs come in and say, citizens need these. Why do they need them? If even though we admit that it's not been a lot of situations where 15 rounds have been fired at a criminal, and the answer is reserve capacity is essential, because we know that even a trained professional is going to hit his target in these sorts of high-stress situations. About 30% hit might not do it. You might have to have multiple hits. You might have multiple assailants. You combine all of these factors, limiting citizens' availability, especially a citizen who, when they start the fight, probably only have what's in their weapon, unlike law enforcement who have spare mags hanging on their belt. If you only have what's on your weapon, in your weapon at the start of the fight, you need to be prepared for whatever's coming.
Yeah, well, I always say one gun is two is one and one is none.
Yeah,
applies to guns and magazines, but yeah, that tends to be the case. I know it took multiple law enforcement officers more than 60 rounds to subdue one untrained man.
Right.
And these are, quotes, trained professionals. And one of my friends, Congressman Thomas Massey, asked the question. He said, so why do you think that a single mother who wants to defend her house should have less capability than these law enforcement officers?
And why should a single mother who wants to defend her house should have less capacity than the people attacking her? Because the people attacking her are going to have these magazines. They don't care what HB 1224 Let me tell you something. This might be a secret, but I'm going to let you in on something.
Yeah.
Criminals are infamous for not caring what the law says.
By definition.
That's right.
Now, there was a discussion about banning all magazines, and that, of course, House Bill 1224 bans magazines that are readily convertible to, quotes, large capacity magazines.
Which is all magazines.
Which is
practically all
basically
magazines.
All magazines.
Yeah.
It means if you have a removable base plate, and we proved this in court. We had Mark Pasamanik, an engineer and a firearms designer, come up and show the court and show the boom, 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 did his timing, did it on video.
The longest it took him in 4 mags was 38 seconds. The shortest amount was 16 seconds.
And he was being deliberate and slow.
Yeah.
He probably could have done it in half that time if
Right.
he really wanted to. And it's not that difficult. And removable base plates. And so the concept was that once you banned all those magazines, and we all know that a magazine-fed firearm without a magazine to fit in it is essentially worthless.
And even the state concedes that if it applies to magazines with removable base plates, it's unconstitutional under any conceivable standard of review.
That's right, and there was some debate about that from the justices and questions about whether it was designed to go that way. Well, the founder, I'm the only person that I know who in that room, including the justices and the Attorney General's office, even you, who was actually there at every single hearing of this bill in the Colorado legislature right here across the street. And I can tell you, there was a lot of discussion about base plates and whether it would apply. They all knew exactly what they were doing.
Exactly. You've got removable base plates. He did basically sort of the same sort of demonstration that Mr. Pasamanik did at trial and said, you're just about to outlaw all the magazines out there because they're all readily convertible. And they did it anyway. No one disagreed with him, much less refuted it.
Yeah, they didn't even disagree.
Yeah.
And so of course our case is then you've just banned all these firearms. Any magazine-fed firearm, then you banned because their magazines could be converted. And hopefully that's a compelling case to the court that you can't really, I don't know any way to split the baby.
Yeah, so we actually said with respect to this particular issue, we would encourage the court to sever the text. Just say that it's on its face unconstitutional or has an unconstitutional effect, and therefore we're taking it out of the statute. And so they've done that practically already with the constructions of the statute below. We're saying if you're going to do that, do it expressly instead of by application.
Okay, now we made our case.
Yes.
And we made it over and over again. You gave them a decision and to strike down the magazine ban. Some people will say, and they have said it, oh, no chance, and why would you do this, and you're wasting your time. And my response to that is always, courtrooms are always a roll of the dice, and you never know what's going to come out of them. Many people didn't think anything good would ever come out of California, and there have been some good decisions out of California. But you definitely never know if you don't try.
Right.
And from RMGO's perspective, we had to make a run at this because we're trying to overturn it in the legislature, but not been able to. Would you, people ask me what is our best chance here, what would you handicap us, and I say, look, if I knew that, I'd go out and buy a lottery ticket.
Well, let me just say this first. We've already won in some respects. We're talking about this readily convertible magazine issue. We have, by bringing this case, forced the state to say, well, it doesn't apply to magazines, really. I mean, the Attorney General has technical guidance out there basically saying it doesn't apply. It's not
doesn't
effective.
apply to convertible magazines.
Doesn't apply to any of the magazines that presently exist. So by forcing that admission out of the state, we've already gotten a practical severance. I also think there's a good chance that we'll get a formal severance of that readily convertible text because it really is, I think, the legislature intended for it to be exactly what we said it was, and if the court gives that intent any sort of credence, they have to sever it.
And best case scenario?
The best case scenario is they adopt our construction of Article 2, Section 13, which says it's basically a text, history, and tradition test that says that if you sweep within the purview of a regulation, common lawful activity, it's unconstitutional. It's similar to the Heller test. If you common lawful use, if you try to ban it, it's unconstitutional. That's what we're going for. We've asked the court to do that. But even if they don't do that, I would say there's a 90% chance that they're going to and raise the standard to what's called intermediate scrutiny, which would give judges below a chance to actually really dig into these statutes that come and ordinances that come down the pike. I think we have a good chance of winning on that point.
Because if they don't have any kind of standard of scrutiny,
and Robertson's is no standards of
then
scrutiny.
you're saying, you said this in court, that Article 2, Section 13 is a dead letter.
That's right. Because the Second Amendment sets a floor. You can't say that it provides less protection than the Second Amendment.
Yeah. Well, now, when would you expect a decision?
It usually takes a few months. I expect late winter or spring.
Okay. And do we need to mention all the plaintiffs? I mean, we've had some people involved in this. Originally, John Sternberg.
John Sternberg has been with us for 6 years. RMGO has been there all the way, and the National Association of Gun Rights have been there all the way. And while I'm talking to the RMGO members, let me just first tip my hat to this guy who knew it was going to be a long to this point, and he took it on. And to all the members whose donations have funded this fight, not just my fees, but we spent tens of thousands of dollars on expert witnesses and trial expenses, etc. And we couldn't have done that. We literally could not have challenged this law without the support of the RMGO members.
Yeah, and so a lot of great people, and we had a couple people here in court today. We had it in the appeals court. We had it in the trial court. Some people who showed up and just kind of showed support. Not, it's a little odd in a courtroom, but a lot of you people who got given input to this entire battle. And so whatever happens, this is really a mark on your belt. You fought the fight, and that's about all you can do is fight as if it all depends on you. Pray as if it all depends on God, because it kind of does, and we'll see what comes of it. So
thank you.
We'll be reporting back soon. As soon as we know, we'll probably have another recap of this in a week or two. Thank you.
Thank you.